This time here, I'd like to call to order the zoning board of review acting as the zoning board of appeals. Tonight, Wednesday, November 30th, 2022. I'm gonna do a roll call at this time.
Bob Crow,
Here,
Keith Cloutier,
Here.
Len Doig,
Here.
Russ Lockley,
Present.
Ed Ionati,
Here.
Mike New,
Here.
Ross Pelletier.
Here.
okay, let the record reflect, we have 5 full-time members and 2 alternates sitting, correct? Also, I'd like to have in a roll call as our attorney, Stephen Angel on the record. If you don't mind.
Solicitor Stephen Angel,
Here.
Okay, and also our town planner is also here.
Herb Durfee, Director of Planning and Development.
Thank you. Okay, at this time here, I'd like to point out the fire exits are to your rear. These 2 exits take you into the buildings. They are not fire exits. 2 fire exits are to the rear. Okay, at this time here, I'm going to turn because this is a Board of Appeal, which our attorney is much more knowledgeable about than I am. And I'm going to turn the meeting over to him at this time.
Thank you, Mr. Chairman. And for the benefit of the board, and for the benefit of the public that's assembled here tonight, I'd like to just give a primer on just what the function of the Zoning Board of Review is tonight. You are sitting this evening in your appellate capacity. You are hearing an appeal of an aggrieved party or parties from a decision made at the planning board. That is a function of what you do as a zoning board of review. It is a rare function. You may not have heard an appeal, if at all, or certainly not perhaps in recent memory. So please bear in mind that there are, even though you may have your hat on that says we're the zoning board of review, the hat you wear tonight is a little bit different. You're hearing an appeal, okay? You're not going to hear from witnesses. There isn't going to be a Q&A. This is about the reasons why those who have appealed the decision think that that decision was wrong, okay? We will be voting to open the public hearing, because this is a public hearing at which the applicant before the planning board and those who have taken an appeal will be heard. We will open that public hearing to hear them give their reasons, one party for why they think the planning board decision should be upheld, and those who have taken the appeal, the reasons why they think that that planning board decision should be reversed. You're going to hear those reasons tonight, and you're going to listen. There is no Q&A of witnesses. There is no presentation from your planning department. You're accustomed to that as you sit as a zoning board for other reasons. For example, there is no site visit. If you wanted to visit the site, that is not part of this process. Okay. My recommendation to the chairman will be to entertain a motion to open the public hearing, at which time you will begin to hear, in this particular instance, the appellant, which is what you call the party that has appealed the planning board decision, Mr. Rastigian. He has indicated in his papers that there are additional appellants. Okay. You will deliberate at some point, but you won't deliberate this evening. You're going to hear both sides tonight. Hopefully we will conclude tonight. My recommendation to the chairman is that at the conclusion of hearing from both the applicant before the planning board and those who have filed an appeal before you, that at the conclusion of them stating their reasons of appeal, that we will give them a couple of weeks to submit proposed findings to this board for your consideration. My suggestion to the chairman was that we set a meeting 30 days from the last hearing on this issue, assuming that, there may be one more hearing date. And I will guide you through this evening so that we're clear. We will close public hearing either tonight or upon receipt of the memos or whatever other additional papers the parties wish to submit to us. And then the next time we get together, assuming that we have closed public hearing at that time, we will consider the decision that you would like to make. And the solicitor's office will put before you, based upon the submission of what's in the record and any post-hearing submission, proposed findings of fact for you that both either go in favor of upholding the decision of the planning board or reversing that. And that night, you will deliberate on that decision and ultimately decide which one you will choose. It is the record that is made here this evening that is appealable to the Superior Court by either party who essentially feels aggrieved as a result of this board's decision at the conclusion of this matter. That's why we have a stenographer this evening. That's why we have a record. Not unusual for you folks. You are a board of record. But her function here tonight is really to provide the record that the Superior Court would consider in the event of an appeal from a decision made by this board sitting in its appellate capacity. If you've ever seen a Supreme Court argument, gentlemen, this is your chance to be just that, to listen to the arguments, and procedurally, we'll make sure that, the appropriate testimony comes in. Again, this is not a Q&A from the public to the board. It is an opportunity for those appellants to state their reasons why they think the decision should either be upheld or reversed. That's what you're here to do, to take notes and to listen this evening. And certainly if you have procedural questions, that's why I'm here. Mr. Chairman, is there anything else that you would like me to address at this time?
Not at this time. I understand that I'll wait till the appellant decided, I'll refer it back to you.
So there is one item I would like to mention. So you have a board of 7 and you seat 5 regular members and 2 alternates. Okay. The alternates vote, obviously, when there is a vacancy among regular members. I am pleased to see the alternates here tonight because this is a rare animal. It's an opportunity to learn. You will see this again. That said, however, those regular members who are sitting tonight must be the same regular members under state law who vote on this appeal. Unlike other matters that may come before a zoning board where your alternates sit and they hear testimony and you have a vacancy the night of the vote and the alternates get to vote. That is not what happens in an appellate capacity. The same group that hears the appeal must decide the appeal. So we sit 5 regular board members. You 5 will vote on this appeal. However, all is not lost for the alternates. You will have your chance at another point in time if we hear an appeal and there's a vacant seat among the regular members. And I think it's important that you be exposed to this. It's a rare animal for a board like this to sit in an appellate capacity. So it's an opportunity and it's a little bit of new ground for you. And it's something that I've worked with before. So I am familiar with the nuances and the peculiarities of it. Does anyone have questions from the board to me as to what the procedures may be, through the chair, of course?
I don't see anybody that has any. Thank you very much.
Mr. Chairman,
Thank you, Mr. Chairman.
may I ask the solicitor a question
Please.
based on what he said? Mr. Solicitor, you mentioned that there might be an opportunity that the board grants the parties for potentially having 30 days to do a findings. In that instance, I assume the public hearing must remain open
Yes, it will.
because as soon as it's closed, they only have a 10-day window.
Yes, I'll be giving that advice at the end of the hearing, depending upon where we stand at that time. I will be advising the board. Thank you. Thank you, Mr. Chairman.
Thank you. Okay, at this time here, we have taken a roll call, and I'd like to open the public hearing on this appeal.
I make a motion, we open up the Coventry zoning board of appeal.
Okay,
Public hearing.
Okay, I have a motion made. I have it seconded by Russ. Keith has made it. All those in favor say aye.
Aye.
Nays, ayes have it. Okay. I'm gonna open up the, meeting with a reading on the record, the notice of appeal from the secretary.
In re appeal of Hopkins Hollow Estates in the matter of Hopkins Hollow Estates proposed major residential cluster subdivision. Appellant is Arthur Rustigian and other alleged aggrieved parties. Location is AP 308, lot 28, 323 Hopkins Hollow Road. The zone is RR5. Appellant is appealing the preliminary plan decision of the Coventry Planning Commission granted September 28, 2022, and recording on October 4th, 2022, in book 2261, page 625 to 629.
Okay, the appellant is here. Appellant? Okay, can you please step up to the podium? Do I swear the appellant in? Yes, okay. I'm going to ask you to give your full name and address, please, sir.
It is Arthur Rustigian, Rustigian, 401 Hopkins Hollow Road, Green, Rhode Island.
Okay, I'm going to ask you to raise your right hand. You swear to tell the whole truth, nothing but the truth in front of this board?
I do.
Okay, I also see here that you have elected not to be represented by an attorney. Am I correct?
I don't know if we chose it that way, but there is no attorney. I'm not a
Well, it
lawyer.
says right here, is the appellant represented by an attorney?
Oh, right,
Yes or no?
Exactly.
So you've elected not to be elected by an attorney?
Yes.
Selected,
Yes.
okay. All right. Floor is yours.
Just as procedural, do you want me to run through my entire thing with opening statements, evidence, or do the whole thing, or what?
I really can't tell you what evidence to present you.
Well, no, I'm not saying what, but I mean, do you want me to go through my whole begin, middle, end?
Whatever reasons you would like to put on the record as to why you think the planning board
Right.
decision should be overturned.
Okay. I'm going to run through my whole thing. Okay. I have stuff. This reference. Thank you. I am Arthur Rustigian, and thank you for taking this hearing tonight. And as said, we are not represented by a lawyer, and hopefully we stick to what we're supposed to stick to. Our appeal is not a case of NIMBY, not in our backyard. We're not opposed to Hopkins Hollow Estates just because it's next to us. Many of us have been concerned and involved in the preservation of the western end for many years. Many of us are lifelong residents of Green, some for generations. Many of us have spoken out at a variety of hearings back at the gravel pit days and the tractor trailers pounding down Hopkins Hollow. We were vocal in opposing the solar arrays on Hopkins Hollow Road and on Lewis Farm. And there was a previous attempt at a building development at Camp Green, which we spoke out, which we were active in as well. And with the number of Green Company lots set aside, they are very concerned about forest preservation and open space as well. To the specific decision of the Planning Commission, we're arguing 3 points: that the Planning Commission didn't have sufficient evidence to approve the preliminary plan for Hopkins Hollow Estate on August 24th, 2022, lacking the supportive weight of the evidence, which again, I will provide some evidence for, contending that the Planning Commission made a clear error by not adhering to the town's comprehensive plan. Again, I'll get to the reference packets later, but evidence there, and concluding a clear error by not contending a judicial. Read the words. Last, we are contending a prejudicial procedural error, not being informed of right of appeal, or that contending a prejudicial procedural error by not being informed of our right of appeal, that the planning commission can in fact revise its decision. And I believe, as the town solicitor said, this is a rare event, and in part might be the reason why due process wasn't discussed, because it wasn't something that ever came up. Due to lack of evidence, that's the first sheet that you have there, where the motion on the 24th contained over 20 deficiencies or things not met. And while that may be common, there was so many that we believe that the plan should not have been approved with so many outstanding issues. Wetlands weren't addressed. Traffic wasn't addressed. Water drainage wasn't addressed. No approved septic system. And the first several pages are from the minutes of that meeting. That is that's the motion that was made by the planning commission with all the deficiencies that they noted. While the planning commission stated that these deficiencies had to be met by the applicant, they were to be reviewed and approved by administrative action only. By moving it to administrative action only, the process is removed from public oversight. We would not know whether these deficiencies or remedies we would not know whether these deficiencies were remedied unless we took on the burden. We would need to go to town hall. We would need to check several times a day, go through the file. Or we would have to file a public records request to find out whether all of these were met. This wasn't a case of one or two missing items, but like I said, 20 or more. We're confident the Board of Appeals will agree that allowing a project of this magnitude to go forward without additional public hearings to know that all of these significant deficiencies were met would be a disservice to the Coventry community. We're confident that the Board of Appeals will agree that passing off so many important deficiencies to administrative action cannot just be standard operating procedure, or should not be standard operating procedure. Excuse me. As to clear error, the Planning Commission stated on September 28th, 2022, during the ratification vote, and this was again from the minutes, that the project was consistent with the comprehensive plan, notes that residential cluster subdivisions is a mean to preserve open space. But this project, in fact, is in direct contradiction, we argue, to many of the clauses in the comprehensive plan.
In direct contradiction,
This project is in direct contradiction to many of the clauses in the town's comprehensive plan concerning the ban on intensive development and suburbanization of Western Coventry. If you go a few pages into your reference packet, there is one titled Town of Coventry Comprehensive Plan. And again, I'm not going to read every one of those. The bold is my emphasis, but they are all right from the comprehensive plan. And all of those sections bolster the fact that the western end should remain rural, that intensive development should not occur, that the town is in fact charged with preserving and protecting environmentally sensitive land. The section on the Audubon holding Western Coventry land and talking about connecting parcels. Well, this parcel connects to the Green Library, which connects to the Trestle Trail, which is a greenway path that is being developed, and that this land would probably be much better suited to be connected to that than to be deforested and houses put up. Again, from the comp plan, about the middle of the page, the town is charged with protecting the distinctive rural character of Western Central Coventry from the threat of suburbanization or urbanization. We contend that no matter how you slice it, 7 houses in a row on the road is suburbanization or urbanization. And I don't see how it could be otherwise, hence our challenge. Again, a charge to protect the rural western end. That's a double typo. And the very last one there, during the last several years, there's been a steady influx of residential development in Coventry, causing Coventry citizens to be concerned about the rate, location, character, and growth of the town. Protection of Coventry's open space and rural character has surfaced as a top priority, and in part why we're here today. The cluster ordinance itself states that these types of projects need to create an attractive neighborhood that maintains rural character. The residential housing portion of this project does not maintain rural character despite its open space provision. And also in your packet, there's a section from the subdivision rules. And in that section, it echoes a lot of the similar things from the comprehensive plan. That cluster developments are only allowed when it can be demonstrated to be in the best interest of the residents of Coventry. Given the number of people, the abutters and people in the neighborhood that have spoken out against this, they clearly don't see it as a best interest of residents of Coventry at all. Other sections from the residential cluster developments sub-rules, maintaining rural character, maintaining consistently with the characteristics of adjacent parcels. Well, the adjacent parcels, most are 5 acre or more, and the ones directly across the street are grandfathered lots. So while it may seem to be several houses in a row, those lots were there before the RR5 was instituted. The development or septics or wells is supposed to be suitable. Like I said in the weight of evidence section, there is no indication that acceptable septic and wells have been approved as of yet, as far as I know. Open space, of course, to be maintained. Again, from the regs, that the design is to create a functional and attractive development. I'm sure that's a subjective phrase, but certainly none of the people in the community consider what's being proposed as an attractive development at all. To sum up that point, then, we're contending that the Planning Commission did not conform to the comprehensive plan as stated in that consistency clause at the top, and in fact is in direct violation or contradicts the comprehensive plan and many clauses there. In the third section or last section is about a prejudicial procedural error. Abutters to the project and other concerned Coventry residents weren't informed of due process rights of appeal at any point until the August 24th, 2022 meeting, the day the project was granted preliminary approval. And this topic did not come up as a matter of informing the public. Rather, it was discussed because of a concern the Planning Commission had as to whether it could reverse itself at the point of preliminary plan. In that scenario, there was a concern that were they to reverse themselves, that the applicant could then appeal the decision, and we would have perhaps the same meeting with reverse roles here. While I don't have the YouTube video, there was an audible stunning in the room when we heard that right of appeal was even available to us. In the packet. And it is a bit lengthy to read, but the discussion came up about a right of appeal. And then, again, not to bore you with reading text, but my general summary of what was going on there was, the solicitor said early, this has not happened, maybe not happened ever, certainly not happened in anyone's institutional memory. And then the explanation of what right of appeal and what the process around was got bogged down. And several of the people in the audience of public discussion were trying to get information from the town solicitor and some of the planning commission members. And then it kind of became, well, you're going to have to go find that out. You know, we'll point to some state statutes, but you're in charge of finding out what the appeal plan was. Hence our claim of a lack of due process. Last point on this, that there's language in the letters that need to go out to abutters, and that is maybe the next to last page. It comes from the Coventry subdivision regulations on letters that go out to abutters. Now, normally this goes out as the applicant did, that there was going to be a public hearing about Hopkins Hollow Estate, and the appeals process required the same letters to be sent out. Again, the bold is my emphasis, but section 5, that letters going out to abutters is supposed to contain a statement that the planning board may revise their previous ruling. Taken liberally, revise can mean to reject it, to deny it. And that discussion was going on. 3 of the members on the August 24th hearing, 3 of the members voted against the approval. So clearly the planning commission could reverse itself, but that discussion seemed to suggest that they couldn't. As they say, absent in the applicant's letter, that the planning commission can, based on either further study or public hearing comments, could change their minds. So that admission was an additional denial of abutters' due process rights, contradicts some of the discussion by members of the planning commission on that day, inferring that they couldn't change their mind if they had approved a master plan. As I mentioned in my wrap up, as I mentioned in the opening statement, many of us have been very active in local planning and zoning affairs for years. Never in a decade or more, and I've been to a lot of meetings on a lot of different issues, or as waiting for my issue to come up, listening to dozens of other issues that have come up. Never has anyone ever heard about an appeal process or the possibility of if you don't like this decision or if you feel aggrieved in this decision, there was a way to sort through that. Also, none of us are lawyers, so it might not have been an obvious thing to think of. Any reasonable person would believe, given the gravity of the Hopkins Hollow project, that the Planning Commission has an obligation to inform the public about due process rights at some point. And while some may contend that the burden of understanding due process, that the knowledge of the appeals process is the burden is on the general public, I certainly don't believe that that is persuasive in this case. I think I got to the end of my list. Thank you for listening.
Mr. Chairman,
Please.
address the board quickly. As the solicitor explained, this is a matter of record, and in that light,
Record,
I'm sorry, Thomas Cronin, Nolan Bernero Cronin Farrow, 1070 Main Street, Coventry, Rhode Island, for the appellee, John
Okay.
Studley.
Raise your right hand. You swear to tell the whole truth, nothing but the truth in front of this board?
I do.
Okay, thank you.
So, Mr. Chairman, I don't mean to interrupt Mr. Estigian's appeal in any way. I simply must protect the record and note my objections. So I note an objection anytime that Mr. Estigian says we or us or speaks for other people, like how the Green family feels about protecting the land out west in Coventry. He's allowed to speak for himself and express his own opinions, and not allowed to speak for others, and I object to that commentary. With regard to the matters, the document that he handed you, to the extent that it accurately describes the comp plan, the zoning ordinance, the planning regulations, I have no objection. Any commentary or bold or emphasis, otherwise, I object. And those are simply for the record, and I don't mean to interfere with the process. Thank you.
Thank you.
Respond?
Yes, please.
Thank you. As to the it was a choice on my part. Mr. Cronin's right. I speak for myself. I have no issue if all the we's are changed to I's in the transcript. I absolutely am only speaking for myself, and other people can speak as well. As I put on the reference sheet, the bold was my emphasis, and only to save some time and direct you to the relevant sections. It wasn't an attempt to alter the language in any way.
Thank you.
Mr. Chairman, if I may, the board can vote to accept the compendium of documents provided by Mr. Estigian as part of a post-hearing submission, and give those parts of it their weight as may be required by law, and those parts that may be disallowed by law would be addressed in a decision of the board. So for the sake of accepting it into the record, it's not new evidence. We are not accepting new evidence this evening because this board is simply looking at what was done at the planning board level and its decision. So we're not hearing new testimony. We're not hearing new evidence. We're not accepting new exhibits. But to the extent that this is a writing provided by Mr. Estigian, it may be accepted upon vote of the board as a post-hearing submission. We can deal with this at the end of this evening's proceedings. I just point that out to you. It's nothing that needs to be addressed at this moment.
Okay. All right. Is there anything else that should be heard on?
I'm sorry, Mr.
Yeah,
Chairman.
is there anything else we should be heard on this, if the appeal wishes to
Well,
present anything else?
Well, Mr. Estigian has stated his reasons for the appeal. It should be noted for the record, Mr. Chairman, that on the face of the appeal, the appellant is named as Arthur Estigian. However, following his signature line, he indicates that there are additional appellants' names and signatures, which are also part of this document. We're not passing judgment at this moment as to whether or not a proper appeal was made, but out of an abundance of caution, if these people are present and they wish to be heard, I think that they should be heard out of an abundance of caution.
Okay,
Mr. Chairman, may I be
Cronin?
heard on that?
Yes.
I am in agreement with the solicitor. Procedurally, I object to anyone else having an appeal in this matter. There's no other written appeal. There's no evidence that anyone filed a filing fee or has a reason stated that they're an aggrieved party. However, I believe for the fullness of the record that they should be heard, and that we'll make those decisions once we hear from them. On the face of the appeal, they haven't met the burden of participation. But if they're here and they testify and they develop that information while they're at the podium, then so be it. Thank you.
Okay, so this would not be considered a question and answer.
It is not. They would make these folks who are listed, and I think you should take them in the order as they appear, can come up and say their piece, if you will, similar to that of Mr. Rustigian, and the board may consider that in the context of their reasons why the planning board decision should be overturned. But it is not a question and answer, and we are not accepting new evidence at this time.
Okay, so for example, the first name is Stephen Petracca. That would be we ask if this person is here and would like to speak.
That's correct.
Okay, is Stephen Petracca here? I'm going to ask you to give your full name and address.
Stephen Petrarca, address is 105 Hopkins Hollow Road, Greenwood Island.
Okay. You can raise your right hand. You swear to tell the whole truth, nothing but the truth in front of this board.
I do.
Okay.
I'd just like to say that I agree with Mr. Ostinian about his comments. Very concerned about the impact of this development in the town of Green. And I think that's all I have to say.
That's all you have to say.
All right.
All right. I thank you for coming out.
Thank you.
Okay, the next person is Robin Petracca. I'm going to ask you your full name and address.
Robin E. Petracca, 105 Hopkins Hollow Road, Green, Rhode Island.
Raise your right hand. You swear to tell the whole truth, nothing but the truth in front of this board.
I do.
Thank you.
I am here again because I support Mr. Rustigian. We have been meeting as a group. We have been faithfully coming to the planning board meetings, and Mr. Cronin knows very well. He looks around the room and he'll see familiar faces. We have all gotten up and spoken before. So for him to say that Mr. Rustigian is wrong to speak in referring to this as we, he does rightfully speak for all of us. We are greatly disturbed by the idea that they want to build this development with houses that are so closely situated on a very dangerous corner in an area that is rural, very rural. It would greatly change the area. I'm not going to get emotional about the whole thing, but I am strongly connected to the area, having lived my entire life in the village of Green, in the town of Coventry, teaching for the town of Coventry. And I am a devoted member of this community. And I feel that this is a terrible mistake to go forward with this plan.
Thank you. Any board members have any questions? You don't want to answer?
There's no Q&A from the board, Mr. Chairman. No problem. I know this is different setting.
Okay. Glenn Underwood, I think it is.
Glenn Underwood, 818 Hopkins Hollow Road, Green, Rhode Island.
Raise your right hand. You swear to tell the whole truth, nothing but the truth?
I do.
Okay.
I think there were several procedural errors made by the planning board in the preliminary, including not weighing in on the financial portion that they're supposed to review before approving a preliminary plan, financial guarantees by the developer. They weren't presented and heard. We were there for the public meeting. You can check the records. They're not there. Many safety concerns were brought to the planning board, and at preliminary, some of these should have definitely been addressed in the plan. It was a public comment that was made about the safety of the corner and the driveways being right on the shop corner where we've had several accidents, including fatalities. And none of this was addressed at preliminary. The town has a responsibility under preliminary to make sure that these things are heard and corrected before we go to preliminary approval, and they weren't. So I think I'm standing behind that there are several things, but those are the two major ones that were not addressed at preliminary that are required to be addressed at preliminary. Thank you.
Okay. Thank you for coming. The next individual is Donna Rustigian.
Good evening.
Please give your full name and address.
It's Donna Rustigian, 401 Hopkins Hollow Road in Green, Rhode Island.
You swear to tell the whole truth, nothing but the truth in front of this board?
Yes, I do.
Thank you.
I'm in complete agreement with everyone who spoke prior to me, including Arthur Estigian. As Robin Petrarca said, we all have been meeting on a regular basis, discussing the issues and the problems that were presented this evening were a culmination of our discussion and identification of problems that were presented in the preliminary plan meeting. And we believe that they should never have made the decision to reaffirm that plan, the preliminary plan to move forward. Had we known that we could have appealed on the master plan, we probably would have been presented to you long before this. So I apologize for not knowing, but I believe that our due process we were not informed of it. While we now know that the procedure to appeal appears in the ordinance sections, we'll know to look for it next time something comes around the corner. But getting to the rest of, I'm in agreement with everything else that has been presented. I think that the 20 counts of deficiencies, I don't think that anyone, including myself or a neighbor of mine who is building an addition, when I built my house, I would never been able to slide by and build my house with all those deficiencies and would have gotten moved on a fast track. So I do hope that you go through the packet and alter the decision to that preliminary plan. Thank you.
Thank you. Okay, next is Stacy Harrington.
Hi,
Please give your full name and address.
Stacy Harrington, 410 Hopkins Hollow Road, Green, Rhode Island.
Raise your right hand. You swear to tell the truth, nothing but the truth in front of this board?
Yes, I do. I too am in agreement with everything everyone has said. And when Arthur spoke and used we have, like everybody said, we have been meeting, and he is speaking for all of us. He was the best one to put it all together and do the speaking. But there's many reasons why that 7 houses should not go where they're planning to put them. Number one is the safety, the road. That was brought up at that preliminary meeting. Also, as far as the comprehensive plan, it's supposed to match the existing setting. And all those houses have such little road frontage. There's one after another. The first one is on that terrible corner where there have been fatalities. Everybody else's road frontage is twice what those houses' road frontages are planned to be. And so it really doesn't match the rural community at all. I grew up there. It's just, it's horrifying to think that that would go in out on the western end. The preliminary meeting, everybody here was at that. And we were never told that we had the right to dispute it. We found out at the second meeting, and I think Arthur said if somebody had YouTubed it, the whole room gasped, because I do believe what happened was there were a few people that were asking questions about it. And I think somebody even said, maybe we can compromise with all these people and make it 6 houses, not 7 houses. There were a few things thrown around how they could, try to compromise. And at that point, it was said that the preliminary plan had already been decided, so no changes could have been made. And if we had wanted to, we should have appealed at the first meeting. And that's when everybody was like, what? Appeal? We didn't know we could appeal. And that's why we're appealing now. A little behind, but we found that out then. Everybody here was aghast that we weren't told that. And it was only that, I don't know. And then the other people that were going to vote, no, they changed their minds and it was approved. We are also very against it.
You say the other people.
There was 3 people on 3 of the
Mr. Chairman,
planning
we
board.
can't engage in a Q&A. I'm sorry.
3 of the people that were going to vote.
Okay, thank you. Okay, is Donald Berger here?
Donald Berger, 410 Hopkins Hollow Road, Green, Rhode Island.
Raise your right hand. You swear to tell the whole truth, nothing but the truth,
I
Father?
do.
Board, thank you, sir.
I first want to say that I have 100% back up Arthur's Prestigian's argument. We all chipped in a lot of money to have this go through, and he did a lot of legwork. It means a whole lot to us people who live there. It was bad enough that they wanted to put a cluster development, but they asked for a variance on the cluster development instead of having a cul-de-sac, which wouldn't have been as bad. Now they got 7 driveways. And the town, they want to grant the variance, but they don't want to pay to have to take care of the road inside the cul-de-sac. So it's like, screw the people. We just want the money. And we want the tax money. So they wouldn't even budge on our request. It's all for Mr. Studley, it seems. I'm all set. Thank you.
Thank you. Okay, Joe Dushan? I'm going to ask you, give your full name and address, please.
Joseph Duchamp, 280 Hopkins Hollow Road.
What's your address?
280 Hopkins Hollow Road.
Okay. All right, you swear to tell the whole truth, nothing but the truth in front of this board?
I do.
Okay, thank you.
I'm just here. I completely support everything Arthur said. My stance is just a safety issue. I've lived there for almost 9 years, and there's been multiple fatal accidents on that corner. I'm a firefighter in Warwick, and it takes well over 10 to 15 minutes to get somebody there. And no, DOT hasn't approved any driveway access, and where they're planning on putting the driveways is pretty much where every car hits the same tree. So that's just my concern. DOT has not done any maintenance on that road since I've lived there. It's a constant flood, and every time it snows, it's just a sheet of ice. That's all I can say.
Thank you. Okay, Robert Thornton, please.
Robert Thorne, 397 Hopkins Hollow Road, Green, Rhode Island.
You swear to tell the whole truth, nothing but the truth?
Yes, I do. Yes.
Thank you.
I'd like to sentiment what Arthur said as far as what's going on with what we've been through. The only reason any of us are here is Mr. Cronin, in the discussion with Mr. D'Agostino, the town lawyer, was talking about 2 or 3 different variants, like Stacey Harrington was saying about changes on the frontage from 50 to 100 feet, 100 feet off the back. These changes were talked about by the board members. And until Mr. Cronin said, well, the plaintiff, Mr. Studley, could object to this. And Mr. D'Agostino said, well, they can object and they have the right to appeal. That's when the board members said, what do you mean we have the right to appeal? Mr. Cronin said, if you change anything, Mr. D'Agostino said, if you change anything, Mr. D'Agostino said, if you change any of these things from this meeting on, you could be held liable in court. Because here's what he said, you are the judge and jury Well, if you're the judge and jury, we were the plaintiff. He's basically the defendant. And in this case, the only reason, like all of the other people that talked to you about, we found out of an appeal is because the town, not that none of those board members had the common decency to inform us of an appeal. They found out through Mr. Cronin that if you appeal it or you change it, he can take you to court. Mr. Studley can take you to court. That's when the appeal came up. Mr. Flynn didn't like the fact that I said, after Mr. D'Agostino said, and so do the town people have a right to appeal. Nobody was ever told about an appeal, not in February, not in August. And it wasn't until the two lawyers challenged the decision that the board members decided to change. They didn't care about us. They didn't listen to us. The only one that they listened to was Mr. Cronin. Because you know what they heard? Lawsuit. That's what you heard. Lawsuit. And you're right, we're here. And if this doesn't go our way, we may go to Superior Court. And there's people on the board that made a decision, and basing on the safety concerns that we have, if someone dies on that corner after you approve this plan and you let an open slate go through, every member of the board will be held accountable in court because somebody could sue the town for that decision. And like was presented to you, there's nothing. No one in this room, not anybody on the board or in this room, could get a permit to build anything on their house or their property with the open check or open napkin that we were given. I've worked on septic systems. I've worked on construction. You can't put a house in without a septic plan. You can't get an approval for a plan. But they had to go through hell to Arthur and Don and Stacy to get their addition put on. They get inspected every time. You can't get nothing done. But yet we get an open slate of a plan for 7 houses built right next to each other. Joe lives right across the street. The person that backs out that driveway is going to back in his driveway. Nobody's done anything. There's no DOT. No member of the board, that board, took a ride up there and actually saw Camp Green, watched the traffic. 6 to 10 buses, school buses come down that road from 6:20 in the morning. I'm up at 5 every day. I'm sharp. I'm on this. Ever since you people started this stuff with us, we're all up on this. Everybody wants to sit in green, calm and relaxed. 7 houses, 2 cars, 14 cars, 7 houses, 4 bedrooms, 28 people. You're talking less than 600 feet. 800 feet, you're going to stuff in 28 people, 14 cars, 7 houses. Septic system. Did they tell you about it? Can't put it in the ground. Got to put it above ground. Water table, 2 feet. Done septic systems. You got a septic system at your house? Is it above ground? Try putting one in Narragansett. See what you'll go through. Try putting one anywhere where there's a high water table. Here, no problem. Put them in. Mr. Cronin's going to tell you everything's fine. There's nothing on that paper. If you get a chance, before you make a decision, punch up the plan for Hopkins Hollow Estates. Take a good look at it. Then you got another plan for Rice City. In your cluster development, why 150 feet? You got a development in Rice City, 14 acres. Bought this up at the last meeting. 12 acres, 150 feet off the road. Why? If you got 14 acres, 12 acres, why do I want to look out my door and see my neighbor 150 feet away when I got 14 acres? Got 40 acres here. No, 2.39, 2.49. 2.99 acres. And like everybody said, if you want to really see what it looks like, take a ride out there. And everywhere you see a ribbon is the start of one property, the end of another. Take a look, like Joe said, where the first one is. As soon as you come around, where 1 or 2 people were killed about 5-6 years ago, right on that corner. DOT came out, put brand new signs up, all arrows, very nice. Right there, straight ahead, into a tree, dead. They got to put a driveway about 50 or 75 feet away from that. School buses, you know, the length of a school bus takes a corner. Here's the corner, comes out, over and in. You know, the average speed limit on Hopkins Hollow is 45. Try to get in a cop out there. 12 to 15 minutes. Like Joe said, going to get an ambulance out there? Good luck. Good luck. And you're going to throw all these people in there, right in that area. I think Coventry really takes the need to look at what you're doing. Because you're not listening to the neighbors. We live in the western part. It's supposed to be kept as a comprehensive plan, safe from development like this. They didn't even, Mr. Flynn and none of the board members even considered from the first development a cul-de-sac. You know, the first thing we heard, town's liability. Town doesn't take care of Hopkins Hollow Road. That's a state road. That culvert where the water's supposed to get out, I've been there 26 years, never been cleaned out. Call the town, not our problem. Call the state, not our problem. This guy is going to come in with his development. That culvert's never going to get fixed. He's telling you the water's going to come down the driveway. They got an easement in the abutments. They got sterns that's going to turn the water away. He's full of baloney. I've been there 26 years. There's a water table that comes right out of the ground 12 months out of the year. You're going to take Todd driveways and pitch the water right into Hopkins Hollow. Got to go in his driveway and everybody else's driveway that's right across here. Because when you have water on a hill, it only goes one way. Here's the culvert, not cleaned out. Another thing, I talked to the fire department. 7 houses, you need a minimum of a 10,000 gallon cistern in the ground. There's 7 houses now. 10,000 gallons you need just to prevent a fire. Because they don't have that many trucks that have that much water. Has that been put on the plan? No. There's no fire plan. There's nothing. Absolutely nothing. You got to look at that plan, folks, before you make a decision. Just look at it. See if you could get away with putting that in to the town for a plan for your house. Just take one of them. Just one of them houses and look and see if you could turn that plan in to the town planning board and they would pass it. They wouldn't. It doesn't have anything on it. It's like somebody sat down with a napkin, put a bunch of straight lines and a couple little deviations. Like Arthur said, there's no well. My well's 400 feet down. There's 7 more wells. Where's that water coming from? Where's the septic going? Town has to look at the overall project. If you can't let a single family person put a development on, an addition on their house, a deck, without going through scrutiny. And another thing, I sat here for some of those meetings, a deck and a little development. Not one person on the board, and I'll emphasize it again, not one person on the board told anybody that had a right to due process. Now, Mr. D'Agostino was nice enough to tell me where to find out the appeals process. Town lawyer. But when you go to court and you represent yourself like we're representing here, you, and you'll know this, have a due process to tell us what the rules are. You go to court to defend yourself for a traffic violation, that judge has to tell you, and you don't have to testify. But we're testifying because we're telling you exactly how we feel. You are developing, you're letting an open slate going with no concern as to what really happens. Because once you prove it and push it past him and send it on, it goes right past all of us. We can't do anything. And the other thing is, like everybody said, nobody said about an appeal. Nobody. We're not lawyers, but we are now. We are now. You forced us. Nobody in this room wants to be here. And I'm sure you don't want to be here. The point is, nobody would have to be here. We never got told the truth from the first meeting. Because if they said, okay, folks, you got these concerns, you have the right to appeal. If you're the judge and jury, you have a responsibility to tell the people, as the judge, what that person's rights are. You can't go into a traffic court and not have that judge read you the rights that you have if you decide to defend yourself. You go to a trial in a traffic court, guess what? You don't have to testify. State has to prove beyond a reasonable doubt with a preponderance of evidence that you're guilty. Here, we're already guilty because you people ain't helping us. I had it written up. I was going to hand it to Ann Dixon. Every committee meeting, anything to do with any planning, as you finish stating what the rules are, you should tell every person that's a citizen of this town they have a right to appeal. Because that's what we do have. That's why we're here. We'd have been here months ago. This would have never gotten here. Because if we're this PO'd now, this is how far it got to make us come this far, because we were forced to. We would have been here in February when we had the Zoom meeting. Nobody knew. We would have found out in August. Nobody knew until the town. If they didn't have that discussion, Mr. Cronin and Mr. D'Agostino, about the liability of the town, guess what? This would have gone through because they opened their mouth about the right to appeal. And the only reason it happened again is because the town was afraid of getting sued. because of two or three changes. 50 to 100 feet of clearance of road clearance. Leave it right. Leave it the way it is. Don't take the bushes up. 50 to 100 feet off the back, take the 100 feet off. Those two changes would have caused an appeal. He would have won. He would have got sued. We would have never known about a right to appeal. Please do us a favor. If you live in this town, take a look what you're approving and take a look at how the system is working. Now, anybody on that board lives in Westman Coventry. Nobody on that board took a walkthrough. As Arthur said, I proposed before, if the town would have taken the opportunity to buy that land at $400,000, you could have turned that into a parking lot. It's a parking lot for what? The Trestle Trail. I'm trying to still get in touch with the state, Almedi, to come down and at least listen to my plan. That place would have been turned into a parking lot. You would have had access and egress right by the conservancy land. Maybe going on the conservancy land with a abutment clause. Straight down, beautiful road, parking lot, 10 cars, horse trailers to access. Straight, nobody's property. It's proposed, too much liability. The town itself has millions of dollars of liability right in that complex in town. And they had the nerve to tell us about liability. Not a road. They won't even want to take care of our road. The state would have been able to take over that project, buy the land through access and egress, and eminent domain could have claimed any land to run a strip right to the Trestle Trail. It would, and there's another, it would have taken all of the traffic that's going to be stuck on Railroad Avenue, Benefit Street, and Hopkins Hollow. That's another thing we would have addressed. Would have alleviated that. Up around the corner parking lot. People come out of the parking lot, they go straight down a beautiful repair, get them right to where they need to be. Wasn't even thought of. But yet, stick the houses in. No plan. We couldn't get away with what the town planning board got away with by approving his plan. None of us. You can't get an addition put on without a permit. You got to tell them what you're doing. I heard a discussion here about 12-foot overhanging farmer's porch or a 10-foot. Oh, the difference is 10 feet is okay. 12 is not. No septic, nothing. No wells, nothing. No driveway plan, no nothing. That's all I got to say.
Thank you, sir.
Mr. Chair,
Yes.
if I might, a simple procedural objection to Mr. Thornton's testimony as to the fire requirements. I can't say whether they're correct or incorrect, but there's no evidence in the record in that regard.
Mr. Chairman, in all fairness, the applicant will have an opportunity to address the board after the appellants do. So my recommendation would be that Mr. Cronin say whatever comments he has for his presentation.
Okay. That's fine. Thank you. Okay, next we have, Ron Stroker, please. Is Ron Stroker here? Stroker, I'm sorry. Not here, okay. Linda J. Curtis?
No.
Not here. John Curtis? James Curtis?
No.
When Linda. Oh, Lee, I'm sorry, Lee Colonna.
No.
No? I figure it's a no. Jonah Harrington? No, I skipped a page.
Skip the page, yeah.
Charles Broder?
Here, I don't have any comments.
Okay, thank you. Jennifer Evinglis? And Randall.
Hi, everyone.
Hi.
Jennifer Evangelista, 420 Hopkins Hollow Road, Green, Rhode Island.
Okay, raise your right hand. Well, swear to tell the truth, nothing but the truth in front
I
of the board.
do. Yes. Charles Broder and I just moved back to town in September, so we haven't been part of this whole thing except for hearing about it from our friends and family. And I just wanted to say, we agree with Arthur, or I agree with Arthur. I don't want to speak for anybody else. We came back to green because it's beautiful and rural and nice and quiet and peaceful. And 7 houses along that road does seem like a lot, and also a dangerous place for 7 driveways. Thank you.
Okay, thank you for speaking. Raymond, Ferry?
Lisa.
Oh, Lisa Ferry. I'm sorry. Not here?
Raymond here.
How about Raymond Ferry? Okay. Johanna Harrington? Okay. Kamara Harrington?
The whole household's got COVID.
So we can skip one.
Yeah, all 418.
Okay, all 4, so.
Yeah, you have to call the names. You have to call the names.
Okay, I have to call the name. Sheen Harrington?
COVID,
Okay, the last one is what? Brendan
COVID.
Harrington? Okay, COVID. Okay. Pamela Thorne.
Wow.
Hi.
Pamela E.
Yeah, pull the mic down.
Waldo.
Yes. Okay, please do your full name and address again.
Pamela E. Thornton, 397 Hopkins Hollow Road, Green, Rhode Island.
Okay, you raise your right hand, you swear to tell the truth, nothing but the truth in front of this board?
Yes.
Okay,
Yes, like my husband was speaking that we've been there for 26 years. It's a country area. It's made to be a country area. This idea of this man coming along who doesn't live there, who has not tasted what we taste, and that's the outsideness. And he doesn't want that. He just wants the houses. He wants the money. That's what he wants. And to put 7 houses, and we're the ones that are next door. We used to belong to Green Company. There, what happened was when they built the next door neighbors there, we came in the early years, and they had camps coming in where kids got to go and live in the outside. And what happened was I forgot it was the pastor who they built the house that we're in now. And then they sold it. I don't think they sold it. There was a woman who already had it. The thing is that it's always been for the country. It's always been for the people to live in the country. And now this man wants to come along and make it into to me, it's going to end up into a big problem, because everyone's going to be trying to use the outside the land, the going up and down the road. That I walk every day. Every day I walk down the road, I have to jump or go into the trees. People don't care anymore about you walking down the road. They don't care. And that's just going to continue and get worse. If we're adding 7 more places for people to live, we who are already there can't even walk down the road. Every day, I walk every day down those roads, and I've tried changing areas, but I end up have to jump into the trees because people don't care. And I'm afraid that this is just going to turn out to be a big mess as far as people not caring for each other. And guess what? We need to do that now more than we ever had in the history of my 66 years of life. No one is caring for anyone else. And all we're asking to do is leave our houses there, number one. Let us have the outside life that we enjoy so much. And I just hope somebody will see that the beauty that we have there, we don't want it to be taken away from us. Thank you for your time.
Thank you. Okay, David Hankins. Please give your full name and address.
David Hankins, 556 Lewis Farm Road.
You swear to tell the whole truth, nothing but in front of this board?
I do.
Thank you.
It's certainly upsetting to me that a plan can pass with such a numerous amount of deficiencies. I mean, who would ever think that? I mean, when people are called to a board, they need all of the information that they possibly can, especially when the comprehensive plan is saying that this has to look like part of the community. How do we base that as taxpayers and neighbors in this area? How can we possibly base that on this limited amount of information? I mean, I don't know what the planning committee thinks is open space. And what I've been told before is that, well, still the estate will have an association and they'll decide what is going to be, what they're going to do with that open space. I don't know if they're going to put a motorcycle track back there, if they're going to cut down the old athletic field and have a baseball field there. We don't know anything about what we don't even, that the houses aren't built, so the neighbors aren't there. What is this plan supposed to look like? I'm very concerned about that. I'm backed right up on the back end of Camp Green. What am I to expect? The 2 feet of water is right under there. A lot of water comes out of there. In the wintertime, I always slow down for that curve because very likely it's going to be a sheet of ice. How many people have gone off the road? Look at the trees there. You'll see big gashes in them. People not familiar with this roadway go sliding right off the road, crash their car. People coming around the corner, dropping. I mean, we got 7 houses here. Obviously, these are going to be family houses with children. The bus is going to have to stop 1, 2, 3, 4, 5, 6, 7. Somebody that's not familiar with the area could come right up around that blind curve and smash into the back of the school bus. What a tragedy we would have then. I mean, I don't know anywhere in the plan where this driveway for that first house coming across the curve is supposed to be. Now, is it supposed to be a joint driveway with the next driveway down? How would we know that? There's no plan. As numerous neighbors have said, we need information. We need a plan. I mean, I don't know what the all-fired rush was to be, to put this all together. Nobody's done anything over there yet. Why wouldn't you just wait for the documents to come in and then have the people come in and say, okay, now I know what you're talking about. And either we say, okay, this makes sense, or we don't like it. We don't like what you're trying to do here. But we're not given that opportunity. And because everybody's in such a fired rush to get things done, I mean, how many days after the decision do we have a chance to appeal? What is it, 30 days? I mean, come on. It just seems like we're trying to get blindsided here. And I got to tell you, being on the Western end, the Western end people are the ones that are fighting to try and keep that a rural area. It's not the Eastern end of town. And we are so outgunned to have one person, which is really half, when you look at the dimension of the town, it's like half the town, District 1. We are so underrepresented. And now the town has gone and got more people for the town council. Nobody from District 1. We are so outgunned here. It just seems like the town is purposely trying to make the eastern end of town, the western end of town, look like the eastern end of town. Now, please, people, I mean, we're trying to fight a climate change here. We're trying to fight for a beautiful place to live. But if people don't start doing this, if we don't start looking out for the ecology, we're just digging a deeper hole. Thank you.
Thank you. Okay, that's the end of the list. At this time here, I'll turn it over to the attorney.
That's the end of the appellant's case. And now it is time for the applicant to present their reasons why the appeal, I beg your pardon, why the decision of the planning board should be sustained.
Okay.
Mr. Chairman, the order, pardon me, Thomas Cronin for the appellee. The order of procedure here today does indicate under paragraph 7 that the appellant will get a chance to make concluding statements. So I don't want to undercut Mr. Restigian in any way. And if he wants to make that statement, I would allow him to do so before I proceed. It's paragraph 7 in the procedure.
It's at the pleasure of the chair.
Okay. Sure, you have the floor.
Arthur Restigian, 401 Hopkins Hollow Road. I just want, I'm not going to be long. I just want to sort of restate everything that we had gone through, that we are challenging the decision based on lack of evidence with all the deficiencies pointed out, that it was an error in not following the comprehensive plan, and that there was issues of due process. I think about the end of the day, but I think in part the way it is designed with all those houses on the road, it's pulling everyone else into the cluster. Mr. Thornton ends up as the 8th house. There's only 48 feet between the end of the project and his house. He might as well move in with them. There's only a two-way street, a 2-lane street, Hopkins Hollow Road, and the house is right across the street. They're now going to be pulled right into this as if they were part of this estate, rather than it being sort of off-road with a road going in. So I think in part, we're concerned not so much, or in addition to all the other things mentioned, that this appears to be a project, whether you want to be part of it or not, you've been made a part of it because you're directly across the street or right next door. Thank you for your time.
Mr. Cronin?
Thank you. Thomas Cronin for the applicant or appellee, John Studley. Procedurally, I'd ask that the appeals, whatever appellant writes, the parties that didn't appear tonight might have be dismissed. Obviously, the board doesn't have to deal with that now. I'm just making the request for the record. So I would ask that the plan be brought up. I'm not eloquent enough to adequately describe it. Be easier to take a look at it. Thanks, Cody. if you could just show the residential cluster, that's fine. That's fine. Thank you. So just going to walk you through the evidence that the applicant set forth at the preliminary plan hearing. Most of what I am saying tracks what is in the transcript of August 24th, 2022. And if the board has any concerns, I can reference the page information. So this is 323 Hopkins Hill Road in Green. It's the former Camp Green, AP 308, lot 28. It's zoned RR5. It's 40.8 acres. Call it 40. It's 40 acres. We appeared before the planning board prior to the preliminary plan hearing, obviously, right? So we had a pre-application hearing before the Coventry Planning Board on December 15th, 2021. We had a site walk with the Coventry Planning Board on January 15th, 2022. We had master plan public hearing before the Coventry Planning Board January 26th, 2022 and February 9th, 2022. Master plan decision was issued for Hopkins Hollow Estates. It's dated February 9th, 2022, and it's recorded a little later, May 9th, 2022. So really that's the leaping off point for our preliminary plan application. We have master plan. We submitted preliminary plan and we had a public hearing before the Coventry Planning Board on August 24th, 2022. No surprise, right? That's what we've been talking about all night. And the preliminary plan decision for Hopkins Hollow Estates came out dated August 24th, 2022 and was recorded October 4th, 2022. You're well aware a notice of appeal has been filed at the town of Coventry on October 21, 2022. So that gets us here. That gets us to today. Our master plan approval was for a residential cluster development. So at the master plan hearing, we presented evidence as to the comprehensive plan, how this fit into the community. And we presented a standard plan where, as one of the neighbors noted, there was a loop road, a town road, 7 lots, 5 acres each. And that's how we calculated the density as is required in the zoning regulations for how many lots we could have in a residential cluster. So 7 fit conventionally in the land, 5 acre lots on a town road. So we use that number and we establish a residential cluster. So one of the requirements of a residential cluster is that there be a benefit. In this case, the benefit is a conservation of nearly 50%. It's 49% of the 40 acres. So you can see on this plan that the western boundary of this Camp Green property is going to remain open space. So the last gentleman who came up said he wasn't sure what that was going to look like. So when we submitted master plan and preliminary plan, we described this open space as conservation land. It's essentially a giant no-cut buffer, right? That each of the houses will have deed restrictions connecting them to the open space and maintaining it as a conservation land that cannot be altered, no motocross tracks, baseball fields, or anything like that. It's going to be open space. They'll have a responsibility to keep it that way. And there'll be a deed for that land, which references their 7 lots. It's reciprocal, right? They're responsible for keeping this to be open space. So as a result of the open space benefit, there's an increase in the density of the lots, right? We have 7 lots on a smaller area of land. And those lots generally average about 3 acres. Some are a little smaller, some are a little bigger. They do have about 160 feet of frontage, as you heard tonight. They have a driveway. We're going to build a single family 4-bedroom house on each lot. So there's the important thing about the construction of these lots and the location of these houses is that they completely conform to the Coventry zoning regulation for residential cluster development. We are not seeking any, well, the reason why you haven't seen me before, right, is we are not seeking any variances. You heard the term variance bandied about tonight by some of the neighbors who came up here to speak. I mean, maybe they think that when I ask for, something in particular, that's a variance, but we're not seeking any relief. This is a conforming project. The land area is conforming, the frontage is conforming, the lot coverage is conforming, the setbacks are conforming. There are some overall aspects of the project who are also conforming. In the front along Hopkins Hollow Road, there's a requirement that 50 feet be left intact. So there's a line on the plan, which is too dense to read here, but take my word for it, that shows that 50 feet of the property in front of the home be left forested. And there is an exception for that. And you'll note in the record that the driveway is the exception to that. So in this case, the electricity is on the other side of Hopkins Hollow Road. Each house will probably have one pole in front of it. Then the utilities will go underground to the house. But right along the street, you'll have a driveway opening and one electric utility pole to bring the internet, electricity, phone, whatever it is, across Hopkins Hollow Road to the side that we're on. So the property right now is mainly forested. There are several old camp buildings on the property, and those are to be demolished. They were described as being in disrepair. Each of the homes is going to have, as you have heard, a private well and an OWTS or septic. So there'll be individual, one for each house. The plan shows the wells in the rear of the property, right? Along each of the backyards will have a well, right? And each of the front yards will have a septic, right? We have to keep them 100 feet apart. That's the easiest way to do that. Heard testimony from Samuel Swarsa, the surveyor and the designer of the site, that the plan is to install an Elgin system here. And as you heard, the water table is about 2 feet. He described the drainage as terrible in his testimony. So we have to fill. We have to fill in front of the house, right? And so the front yard will be slightly elevated. The septic will be in there. It's not going to be above ground. It's going to be above the ground that's there now. We're going to raise the grade. You won't be able to see anything sticking up out of the ground. It's going to look like the front yard. Each of the driveways is designed to have a turnaround. We're well aware that Hopkins Hollow Road, the state road, is narrow. And to avoid any problems for these folks, each of the driveways will have a turnaround in the driveway, so everybody's coming out with the headlights out, not the tail lights out. So some of these things that we've thought about as we've gone along. Mr. Swarsa did testify that the topography does gently slope towards Hopkins Hollow Road. And he noted that the drainage situation would be handled in two specific ways with regard to the house. He said that the downspouts will have dry wells, that'll capture the water. It won't be running across the top of the ground. And he said the driveways will be pitched into swales that run parallel to the driveway. So one of the features you heard the neighbors talk about this evening is that there is a significant drainage swale that runs along the front of these properties. Maybe the state of Rhode Island put it in. Nobody really knows. It's been there for a very long time. Each one of these driveways is going to have to cross that drainage swale. It is significant. It's a good size swale. And each one of the driveways will have a steel culvert underneath it as it crosses from their yard to Hopkins Hollow Road. The culvert, luckily for us, right, is on the property. It's on Hopkins Hollow Road. It's not on the state right away. So one of the concessions that we made to the board, or clarifications that we made in satisfaction of their request, is that we agreed to put into the homeowners association documents that the folks who lived in these homes would be required to maintain that drainage, right? It wouldn't be, as several of the neighbors said, waiting for the state to come out and clean this swale. We're going to put that burden by deed, by homeowners association, recorded homeowners association documents on the homeowners. One of the other things I did want to mention as the planning board has been characterized as a little soft during the testimony here, is that they also asked for and received several concessions from the developer during this hearing. The first was the developer agreed. If you look at this map, you can see that each one of the lots has a significant backyard, and that backyard is wooded. And what the planning board asked for and what we agreed to was to put 100-foot no-cut buffers on the western end, the backyard of each one of these houses, essentially adding 5 acres of no-cut buffer to the already existing open space. So they'll be able to have a backyard as big as they want, but they can't go 100 feet from their property line. That's got to be maintained intact. We also agreed, another neighbor came out from from Lewis Farm Road and indicated that some of the local youths, right, were riding some motorcycles out there. It got a little noisy. And he asked us to restrict the open space to passive pedestrian type use. And we agreed that. We agreed to that. We agreed to put that in our homeowners association documents and in the deed for the open space that motorized use of this property is specifically excluded in order to give the town or the property owners abutting, some avenue to address what I guess is occurring out there right now. So those are a couple of the items that the planning board was able to convince us to adopt in addition to what we presented. When you review the record, you'll also see that they asked specifically about the drainage of the lots, particularly the driveways. They asked where those utilities would be located and how they would reach the house, what that would, in essence, safety and appearance. What is that going to look like? Are you going to have 6 poles? These are pretty long driveways. You're going to have 6 poles. And, we described that there'll be 1 pole and then underground to the house. So those were the areas of concern for the board. Mr. Swarsa testified that he had received Rhode Island Department of Environmental Management subdivision suitability approval and the necessary Rhode Island Department of Transportation permits. One other item that Mr. Essegian just mentioned, and if the board would indulge me, I'll just walk up to the plan and show you because I can't really describe it. That area right there, I'll come back. The southern end of the property in the house right below that belongs to Mr. Thornton, as he described, has that, I believe it's 48-foot open space out to Hopkins Hollow Road. And that's a requirement of the residential cluster design. So Mr. Swarsa spoke about the design of the plan, the 50-foot buffer in the front, the 50-foot buffer to any neighboring residential property, Mr. Thornton's property in this case. No one else is within the 50 feet, so he got that space there for himself. And he testified as to the DEM requirements for drainage, which, as this board is well aware, requires that there'll be no increase in runoff from this property. So all the drainage will be designed and approved by the Rhode Island Department of Environmental Management and the Town of Coventry engineer, so that there'll be no increase in runoff off this property when we finish this project. So it'll be managed. So it's not going to be probably any better, and it's probably not going to be any worse, right? They're going to manage the water so it doesn't get worse. One of the items that has continually come up is the corner. Cody, could you just lower that plan for me for one? The other way, I apologize. So you can see that proposed lot 1 to the very north of this map is on the corner after the library. And one of the requests that we received at master plan was to move that driveway as far away from that corner as we possibly could. And you can see that we have done that. We moved it as far away on that lot as we could get it. And the other request that we received at master plan was that the driveways are offset from the houses across the street, so that when the folks are coming out of their driveway, it's not going into somebody's living room window. So to the best of our ability, that this is what we've done with the driveways. For safety reasons, we moved the driveway on lot 1 as far away from that corner as we could get it. And then we adjusted the other driveways so that they weren't pointing at the house across the street when you came out of the driveway. So that's the basic plan that the board approved at preliminary. One part of the record that's of particular interest is the discussion of the comprehensive plan. Mr. Anderson on the planning board is a resident of District 1 of Western Coventry. He asked me numerous difficult, pointed questions about this project. But one of the things you'll see in the record is that he acknowledges that the comprehensive plan for the town of Coventry waivers is inconsistent on its treatment of the RR5 zone in Western Coventry. On one hand, it's very strident, as Mr. Restigian pointed out, right? He pointed out the parts that say, it should basically be pasture land. But in the same comprehensive plan, it specifically says that a residential cluster development is allowed in the RR5 zone in Western Coventry. So when you look in the record, you'll see Mr. Anderson himself wrestling with this inconsistency. So now this wasn't a secret. The board considered it, and they decided that at master plan, it fit. And then they decided again at preliminary plan that it fit. Mr. Thornton's references to my being a defendant in this matter, which I enjoyed, reference a discussion that I had with the board about our vested rights from master plan in the residential cluster development. Master plan is when you make the decision, the board makes a decision. Is this going to be a conventional subdivision? Is this going to be a residential cluster subdivision? They decided at that time that this is going to be a residential cluster development, and we have those rights. We have the rights to the 7-lot residential cluster development. It's conforming. We're not asking for any variance. And, I pointed that out to the board just the way I'm doing it with you guys today. And, that is the truth. If they can, the planning board at preliminary can make modifications to that, but they really can't trample on our rights too much. So that I just want to clarify that reference. I also wanted to clarify that the developer here has been, I think, reasonable, because a residential cluster development allows lots as small as 1 acre in the RR5 zone. We don't have any lots nearly that small. We tried to be respectful. The size of the lots mirrors what's across the street, although, as they pointed out, they do have more frontage than we do. But across the street is a bunch of houses, right? That's the engineering term for that. Bunch of houses that are also on 2-3 acre lots. They're also close to the road. That's what's there. So when I presented at master plan what this neighborhood would look like, it looks like that. I mean, that's what it's designed to be. I just wanted to introduce the plan and the evidence that we presented to you with regard to the appeal that's before you today. The first thing, I do think that Mr. Restigian, he's obviously a very intelligent man. He makes a good presentation. He's a credible guy. I appreciate his thoughtfulness. I don't mean to criticize him in any way, but there's always a but, right? So the but, in regard to the weight of the evidence in this appeal, We presented a plan stamped by an engineer, testimony by a registered land surveyor, unrebutted. Right? We presented, the designs. There's multiple pages to this plan that, Cody could go through here, but we presented engineered plans that met the standards of the state of Rhode Island and town of Coventry. We presented the testimony of a registered land surveyor, an expert in the design and placement of those wells and septic systems and how that water would be retained on site. And that evidence is unrebutted. There's no evidence on the other side. So when they say the weight of the evidence, there's nothing on the balance. We presented a plan, testimony. There's no rebuttal of that expert testimony. There's really no weight on the other side. I understand that the waiver of checklist items till final might seem foreign to homeowners in town and neighbors, but there's a process to getting this neighborhood subdivided and built. And it's a multi-step process. And preliminary plan is just one of those steps in the process, right? You have experience with some of this, and that, as Mr. Thornton mentioned, that we have to involve the fire department, right? We need their approval. Nobody's going to go around getting fire approval. And if as he suggests, a cistern is necessary, then we'll put one in, right? This is just one step in this process. And these permits are requested and applied for by our engineers and surveyors. They're approved by the state of Rhode Island, the town of Coventry, and they accumulate until we have a plan that can receive final approval from the town of Coventry, get a building permit, get the necessary, we have the necessary DOT permit and subdivision suitability permits from the Department of Environmental Management, but we also need those septic permits, before we build a house kind of thing. We need to get permission from fire. And DOT will certainly be interested in what we do with those culverts, even though it's a little off their land, right? They have every right to. So I think the weight of the evidence is what we have presented. We've presented expert testimony that complies with the law, subdivision regulations of the town of Coventry, and it's unrebutted. I mentioned, I don't want to repeat myself, I mentioned the comp plan and the conflicting statements in our comp plan, and the planning board weighed those conflicting statements, both at master plan and at preliminary plan, and made a decision that the residential cluster subdivision was suitable for this location. Mr. Essegian's last point, the appellant's, all of them last point with regard to due process. So we rely on the zoning ordinance, subdivision regulations, and the state of Rhode Island statutes around general laws with regard to preparing and submitting subdivisions such as this one. Though the rights of appeal are clearly stated in each one of those documents, somebody investigating whether we ought to be able to put this subdivision in and reviewing those items would be able to see that. And in general, that's the notice that somebody who has interest receives, that, you should go look. I don't think I would dispute that the planning board, the town of Coventry, the solicitor has any duty under the law to notify somebody that they have a right of appeal. It does come up sometimes in hearings and it's discussed and things like that. But as to a duty, I think that's one step too far. And I guess as the solicitor has suggested, I might have to prepare some information for the board in that regard. That's a strictly kind of a legal question. So I think that wraps up what I have to say. you know, this is a project that's just about midway, right? We have some solid plans. We have some approvals. We're going to work with the state, the town, the fire department, get the required necessary final approvals. We'll submit to the town of Coventry. As has been mentioned, this is an administrative final, so we'll submit to the department. They usually find a few holes in what we submitted. We go back and we fill those holes, and then we'll get final approval. And even after that, we'll have to go get building permits and things like that. So we're about halfway in this project, and I think that goes a long way to explaining why those checklist waivers, things that we're still accumulating, were included in the decision. You know, obviously the planning board acknowledges that. It's not a secret. They know that we're still working on these permits, and that it's not missing items. They're just items that are still being developed. So I thank the board, and I'll end on those notes. I have a question for the solicitor. Are you going to instruct on the standard of review?
What I will answer your question in the context of my remarks to the board at the conclusion of your presentation.
Okay, then given that response, I'll quickly review what I understand the standard of review to be, and the solicitor may or may not agree, but so the standard review for an appeal to the zoning board of review is the board shall not substitute its own judgment for that of the planning commission or administrative officer, but shall consider the issue upon the findings and record of the planning commission or administrative officer. The board shall not reverse a decision of the planning commission or administrative officer except on finding of prejudicial procedural error, clear error, or lack of support by weight of the evidence in the record. So I just wanted to make sure that I got that into the record and gave the board my position on what their standard of review is. I thank you. Have a good night.
Okay, I'll turn it over to our solicitor now.
My recommendation, thank you, Mr. Chairman. My recommendation to the board at this time would be the following: to entertain a motion to leave the public hearing open as required by law. Otherwise, we trigger the decision deadline. That we provide each of those on the appeal until, I would suggest, a couple of weeks. Let's say December 16th, which is a Friday, at close of business, to present their version of proposed findings of fact and standard of review, if they so wish, for the board to consider, and that this board reconvene at some point after the first of the year, given the holiday break and so forth, to deliberate on this matter and to decide. And that will be done in public. We are leaving the record open only for the purpose of the submission of those materials and not for additional statements by those involved in the appeal, just to be clear. But the nomenclature is to leave the public hearing open. Given the submissions of the parties involved in the appeal, we will provide this board in draft a framework of the standard of review and propose findings of fact. And it is ultimately the board's decision that evening to work with that information as it deliberates. You will have that in advance of your meeting in January. And so, again, I think the board should, with due respect, consider a motion that leaves the public hearing open until its first meeting in January, at which time we will, this board will deliberate and make a decision. And that as part of that motion, all the parties to the appeal will have the opportunity up until the close of business on 12/16/2022 to present their proposed findings of fact and standard of review if they so choose.
Okay, so if I understand this right, you would like the submissions submitted by 12/16.
Close of business. Yes, Mr. Chairman.
Okay, and that would be the findings of facts from both sides, correct?
Yes, they can present their proposed findings of fact.
Okay, I would like.
Mr. Chairman, may I raise a point of order as well, just to make sure I'm on the same page as the town solicitor that so you would be recessing the public hearing to a time certain because this and it would have to be also a date that is not coinciding with the zoning board of adjustment. This under statute has to be a separate.
Yeah, that's fine.
Yeah, I just want to make sure that
whatever the calendar bears, I would want them to fill that date in this evening. It can't be nebulous.
Right,
It
okay.
has to be a date certain.
that's what I want to make sure for the benefit of the folks that are
Yes.
here.
So whatever that date is,
Okay, so at this time here, I'd like to have a motion from the board to keep this meeting open.
keep the public hearing open. Mr.
Keep the
Chairman.
public hearing open for the findings of facts.
And deliberation on the decision.
Deliberation for the decision to form a draft after 12/16/22 date of business.
That is to submit documents from those involved in the appeal. But we're also leaving this open and continuing this meeting to a date certain for deliberation until, and I would defer to the planning department as to what the next, I beg your pardon, the zoning department as to what the next meeting of this committee is in January. What is that date certain?
Okay.
January 4th.
Regular meeting.
Okay. Does that work?
That won't work. You can't do them both.
Right. In my opinion, that cannot, I mean, it could be the same day, just a different time than
That's
the
fine.
zoning board. So you could do it on that, whatever that first Wednesday is in January. I just want to make sure that it's understood there's going to be separately noticed meetings from that standpoint.
Correct.
Okay, so what's the first?
The 4th.
January 4th.
Normal meetings are 7, so it would have to be earlier.
If it's the board's pleasure, the board can do it on another date certain. I mean, that's,
The challenge is we don't know, I don't have the calendar that the town clerk has at the moment to find out when the chambers is open.
So I think the smartest date would be the one you just stated, January 4th.
with a separate notice heard.
Come earlier.
Yep.
If the board agrees.
Good call.
It's the time.
That's our regularly scheduled meeting.
No, it will be,
Earlier.
it will be earlier.
Well, that's our regular meeting day.
Yes.
Regular meeting day, just a separate time because we'll need
Separate time.
a
We can do
separate notice.
Start at 5:30, 6 o'clock.
6.
Is that fine? 6?
6 o'clock, is that fine with the board?
Works for me.
Okay, so I will need a motion from one of the members.
So moved.
Second.
Okay, to keep the meeting open until January 4th, 2023. And also have both sides submit the findings of facts and for a draft work, am I correct?
Yes, they'll provide that to us by 12/16 at the end of business that day.
Okay, is there anything else I need to add to this?
The only other, you need to take a vote on that motion, Mr. Chairman, and then we can move on.
I'm gonna do a roll call vote. I'm gonna start up there with Ross.
Yes.
Okay, you vote yes?
Yes.
Ed? Chief?
Agree.
Agree. I also agree. Keith?
I agree.
Mike?
Right. No.
Okay.
What I would also suggest in deference to the appellants, Mr. Restigian had provided a writing to the board this evening I think it appropriate to accept that submission as part of their post-hearing submission.
That wouldn't be something that he would ask to,
I would assume that he would want that to be, Mr. Estigian, would you want that considered?
okay, that's what I'm,
The appellant indicates for the record that
okay,
he
so you
wants that
want to
considered.
submit that as evidence,
It's not evidence.
Oh,
It's
it's
part
not
of his proposed findings of fact.
proposed findings of fact. Okay, all right.
Okay.
Thank you for the correction.
You're welcome.
Okay, and should I vote on that?
You need to take a motion and a second and a vote on that to accept
Okay, I
it.
need a motion on this for, submit this as findings of fact. Motion to accept. Russ has made the motion, seconded by
Second.
Keith. All those in favor say aye.
Aye.
Nays? Ayes have it. Okay, is there anything else?
Not on this, Mr. Chairman.
Okay. Thank you all for coming tonight. Yes?
I have to close it.
Yeah, you need to take a motion. to
Okay,
adjourn.
I make a motion, we close the motion, the Coventry zoning board of appeal.
You don't want to make a motion to close. You want to
Okay.
make a motion to adjourn.
Make a motion to adjourn.
Okay. Okay, motion to adjourn is made and seconded. All those in favor say aye.
Aye.
Nays? Ayes have it. Okay, we all content now? I guess so.
Good job, guys.
I thank you all for coming.
Thank you. Thank you.